starting in 5 seconds. Writ petition number 76 of 2016 was filed for declaring right to sexuality, right to sexual autonomy, and right to choice of a sexual partner to be part of the right to life guaranteed under Article 21 of the Constitution of India, and further to declare Section 377 of the Indian Penal Code to be unconstitutional when the said writ petition was listed before a 3-judge bench on 8 January 2018. The court referred to a 2-judge bench decision rendered in Suresh Kaushal, wherein this court had overturned the decision rendered by the division bench of the Delhi High Court in Naz Foundation. It was submitted by Mr. Arvind Datar, learned senior counsel, appearing for the writ petitioners on the said occasion that the 2-judge bench in Suresh Kaushal had been guided by social morality leaning on majoritarian perception, whereas the issue in actuality needed to be debated upon in the backdrop of constitutional morality. A contention was also advanced that the interpretation placed in Suresh Kaushal upon Article 21 of the Constitution is extremely narrow, and in fact the court has been basically guided by Article 14 of the Constitution. Reliance was placed on the pronouncement in Nalsa case, wherein this court had emphasized on gender identity and sexual orientation. Attention of this court was also invited to a 9-judge bench decision in K.S. Swamy and another versus Union of India and others, wherein the majority speaking through Chandrachud J has opined that sexual orientation is an essential component of rights guaranteed under the Constitution, which are not formulated on majoritarian favor or acceptance. Cole J, in his concurring opinion, referred to the decision in Mosley vs. News Group Newspaper Limited to highlight that the emphasis for individuals' freedom to conduct his sex life and personal relationships as he wishes, subject to the permitted exceptions, countervails public interests. The further submission that was advanced by Mr. Datar was that privacy of the individual having been put on such a high pedestal and sexual orientation having been emphasized in the Nalsa case, Section 377 IPC cannot be construed as a reasonable restriction, as that would have the potentiality to destroy the individual autonomy and sexual orientation. It is an accepted principle for interpretation that a provision does not become unconstitutional merely because of abuse. Appreciating the said submissions, the 3-judge bench stated that certain other aspects need to be noted. Section 377 IPC uses the phraseology carnal intercourse against the order of nature. The determination of order of nature is not a constant phenomenon. Social morality also changes from age to age. The law copes with life and accordingly change take place. The morality that public perceives the constitutional may not conceive of. The individual autonomy and also individual orientation cannot be changed unless the restriction is regarded as reasonable to yield to the morality of the Constitution. What is natural to one may not be natural to the other, but the said natural orientation and choice cannot be allowed to cross the boundaries of law, and as the confines of law cannot temper or curtail the inherent right embedded in an individual under Article 21 of the Constitution. A section of people or individuals who exercise their choice should never remain in a state of fear. When we say so, we may not be understood to have stated that there should not be fear of law, because fear of law builds civilized society, but that law must have the acceptability of the constitutional parameters. That is the litmus test. It is necessary to note in the course of hearing on a query being made, and Mr. Dattar very fairly stated that he does not intend to challenge that part of section 377 which relates to carnal intercourse with animals, and that apart he confines to consenting acts between two adults. As far as the first aspect is concerned, that is absolutely beyond debate. As far as the second aspect is concerned, that needs to be debated. The consent between two adults has to be the primary precondition. Otherwise, the children would become prey, and protection of the children in all spheres has to be guarded and protected. Taking all the aspects in the cumulative manner, we are of the view that the decision in Suresh Kumar Kaushal's case requires reconsideration. The three-judge bench expressed the opinion that the issues raised should be answered by a larger bench, and accordingly referred the matter to the larger bench. That is how the matter has been placed before us. We have heard the Mr. Mukul Rohtagi, learned senior counsel, assisted by Mr. Saurabh Kirpal, learned counsel, appearing for the petitioners in writ petition number 76 of 2016, Mrs. Jaina Kothari, learned counsel for the petitioner in writ petition number 572 of 2016, and Mr. Arvind P. Dattar, learned senior counsel for the petitioner in writ petition number 88 of 2018. Stop. Starting in 5 seconds. Going further, we have heard Mr. Tushar Mehta, learned additional solicitor general for the Union of India, Mr. K. Radhakrishnan, learned senior counsel, appearing in interlocutory application number 94 of 2018 in writ petition number 76 of 2016, Mr. Mahesh Jethmalani, learned senior counsel, appearing in interlocutory application number 91 in writ petition number 76 of 2016, and Mr. Soumya Chakrabarti, learned senior counsel, appearing in interlocutory application number 94 of 2018 in writ petition number 76 of 2016. It is submitted on behalf of the petitioners and the interveners that homosexuality, bisexuality, and other sexual orientations are equally natural and reflective of expression of choice and inclination founded on consent of two persons who are eligible in law to express such consent, and it is neither a physical nor a mental illness, rather, they are natural variations of expression and free thinking process, and to make it a criminal offense is offensive of the well established principles pertaining to individual dignity and decisional autonomy inherent in the personality of a person, a great discomfort to gender identity, destruction of the right to privacy, which is a pivotal facet of Article 21 of the Constitution, compatible to the highly cherished idea of freedom, and a trauma to the conception of expression of biological desire, which revolves around the pattern of outline of true manifestation of identity. That apart, the phrase order of nature is limited to the procreative concept that may have been conceived as natural by a systematic conservative approach, and such limitations do not take note of inborn traits or developed orientations, or for that matter consensual acts which relate to responses to series of free exercise of exertion of one's bodily autonomy. It is further argued that their growth of personality, relation building, endeavor to enter into a live in relationship or to form an association with a sense of commonality have become a mirage, and the essential desires are crippled. It is urged that the American Psychological Association has opined that sexual orientation is a natural condition and attraction towards the same sex or opposite sex are both naturally equal, the only difference being that the same sex attraction arises in far lesser numbers. This has been concluded in some of the research reports by various research organizations. As such, the petitioners in their arguments have highlighted that the rights of the gay, bisexual, and transgender community, who comprise 7 to 8% of the total Indian population, need to be recognized and protected, for sexual orientation is an integral and innate facet of every individual's identity. A person belonging to the said community does not become an alien to the concept of individual, and his individualism cannot be viewed with a stigma. The impact of sexual orientation on an individual's life is not limited to their intimate lives but also impacts their family, professional, social, and educational life. As per the petitioners, such individuals need protection more than the heterosexuals so as to enable them to achieve their full potential and to live freely without fear, apprehension, or injury in such a manner that they are not discriminated against by the society openly or secretly, or by the state in multifarious ways in matters such as employment, choice of partner, testamentary rights, insurability, medical treatment in hospitals, and other similar rights arising from live in relationships, which after the decision in Indra Sharma vs. VKV Sharma is recognized even by the Protection of Women from Domestic Violence Act 2005 for various kinds of live-in relationships. The same protection as per the petitioners must be accorded to same-sex relationships. It is urged by the learned counsel for the petitioners that individuals belonging to the LGBT group suffer discrimination and abuse throughout their lives due to the existence of Section 377 IPC, which is nothing but a manifestation of a mindset of societal values prevalent during the Victorian era, where sexual activities were considered mainly for procreation. The said community remains in a constant state of fear, which is not conducive for their growth. It is contended that they suffer at the hands of law and are also deprived of the citizenry rights which are protected under the Constitution. The law should have treated them as natural victims and sensitized the society towards their plight and laid stress on such victimization. However, the reverse is being done, due to which a sense of estrangement and alienation has developed and continues to prevail amongst the members belonging to the LGBT group. Compulsory alienation due to stigma and threat is contrary to the fundamental principle of liberty. The petitioners have referred to the decision of this court in Nalsa case, wherein transgenders have been recognized as a third gender apart from male and female and have been given certain rights. Yet, consensual activities amongst transgenders would continue to constitute an offense. Stop. Starting in 5 seconds. In recent years, digital banking, digital payments, and fintech innovations have grown at a rapid pace in the country. Government is continuously encouraging these sectors to ensure that the benefits of digital banking reach every nook and corner of the country in a consumer friendly manner. Taking forward this agenda and to mark 75 years of our independence, it is proposed to set up 75 digital banking units in 75 districts of the country by scheduled commercial banks. The financial support for digital payment ecosystem announced in the previous budget will continue in 2022-23. This will encourage further adoption of digital payments. There will also be a focus to promote use of payment platforms that are economical and user friendly. In recent years, over 25,000 compliances were reduced and 1,500 union laws were repealed. This is the result of our government's strong commitment for minimum government and maximum governance, our trust in the public and ease of doing business. For the Amrit Kal, the next phase of ease of doing business and ease of living will be launched. In our endeavor to improve productive efficiency of capital and human resources, we will follow the idea of trust based governance. This new phase will be guided by an active involvement of the states, digitization of manual processes and interventions, integration of the central and state level systems through IT bridges, a single point access for all citizen centric services, and a standardization and removal for all citizen centric services, and a standardization and removal of overlapping compliances, crowdsourcing of suggestions, and ground level assessment of the impact with the active involvement of citizens and businesses will be encouraged. A single window portal Parivesh for all green clearances was launched in 2018. It has been instrumental in reducing the time required for approvals significantly. The scope of this portal will now be expanded to provide information to the applicants based on location of units. Information about specific approvals will be provided. It will enable application for all four approvals through a single form and tracking of the process through centralized processing center green. The issuance of e-passports using embedded chip and futuristic technology will be rolled out in 2022-23 to enhance convenience for the citizens in their overseas travel. By the time of India at 100, nearly half our population is likely to be living in urban areas as such. For this, on the one hand, we need to nurture the megacities and their hinterlands to become current centers of economic growth. On the other hand, we need to facilitate tier 2 and 3 cities to take on the mantle in the future. This would require us to reimagine our cities into centers of sustainable living with opportunities for all, including women and youth. For this to happen, urban planning cannot continue with a business as usual approach. We plan to steer a paradigm change. A high level committee of reputed urban planners, urban economists, and institutions will be formed to make recommendations on urban sectors, policies, capacity building, planning, implementation, and governance. For urban capacity building, support will be provided to the states. Modernization of building bylaws, town planning schemes, and transit oriented development will be implemented. This will facilitate reforms for people to live and work closer to mass transit systems. The central government's financial support for mass transit projects and Amrut scheme will be leveraged for formulation of action plans and their implementation for facilitating TOD and TPS by the states. For developing India specific knowledge in urban planning and design, and to deliver certified training in these areas, up to 5 existing academic institutions in different regions will be designated as centers of excellence. These centers will be provided endowment funds of rupees 250 crore each. In addition, AICTE will take the lead to improve syllabi quality and access of urban planning courses in other institutions. We will promote a shift to use of public transport in urban areas. This will be complemented by clean tech and governance solutions, special mobility zones with zero fossil fuel policy and EV vehicles. Considering the constraint of space in urban areas for setting up charges station at scale, a battery swapping policy will be brought out and interoperability standards will be formulated. The private sector will be encouraged to develop sustainable and innovative business models for battery or energy as a service. This will improve efficiency in the EV ecosystem. Efficient use of land resources is a strong imperative. States will be encouraged to adopt unique land parcel identification number to facilitate IT based management of records. The facility for transliteration of land records across any of the Schedule 8 language will also be rolled out. The adoption or linkage with National Generic Document Registration System with the One Nation, One Registration software will be promoted as an option for uniform process for registration and anywhere registration of deeds and documents. Necessary amendments in the code will be carried out to enhance it. Stop.